I've worn this robe for 34 years, long enough to understand that justice isn't simply about statutes and camera footage and what the docket says happened. It's about choices. It's about what a person does in the 4 seconds when they think no one is grading them. And on a bright Tuesday morning in September, a case landed on my docket that looked on paper like a straightforward property damage matter. The clerk set the file in front of me. Serena Wolf, 24 years old, reckless driving, failure to stop, resisting an officer. I read the name, then I read who her father was. The moment she walked in, I felt the air in the room change. Some defendants come in frightened. Some come in resigned. Some come in performing remorse they have rehearsed with their attorneys. Serena Wolf walked in the way people walk when they have already had a conversation with someone they believe outranks the room. She was 17 minutes late. She did not hurry. The pale blue cashmere sweater was perfectly chosen. Authoritative enough to be respectful. Composed enough to signal that she had dressed for something that would not take long. Her dark hair was down. Her heels were measured, unhurried. The practiced ease of someone who has attended enough official functions to know exactly how composure is performed. She carried no apology in her bearing because she carried no expectation that one would be required. The real thing she carried into my courtroom wasn't the cashmere or the composure. It was a father's name, and she wore it the way certain people wear a credential. Not displayed, just present, doing its work before she'd said a word. I waited until she reached her table. Ms. Must, Wolf. You were due at 9:05. It is 9:17. Is there a reason the court was kept waiting? She looked up with the mild patience of someone explaining something self-evident. I had difficulty with parking. No, Your Honor, no apology, just a calibrated insufficiency. The way you answer someone you've already decided doesn't require more. Her attorney stepped forward immediately. Your Honor, we sincerely apologize. I nodded at him. Then I looked back at Serena. Miss Wolf, this is a court of law. When it convenes at 9:00, you are here at 9:00. Are we clear? She met my eyes for a moment longer than necessary. Then, of course. Her father was Chief Raymond Wolf, 16 years as the city's chief of police, the longest-serving chief in the department's recorded history. His photograph hangs in the lobby of every precinct in the city. His name has a specific frequency in this city, one that causes institutional systems to adjust around it before anyone consciously decides to adjust. Serena had grown up inside that frequency. This morning, she arrived wearing it. She had brought 2 attorneys, Philip Crane, lead counsel from a firm with a documented history of representing the police union and the city's pension board. A second personal attorney whose separate presence told me Serena understood at some level that this morning might require answers she would have to give on her own. In the gallery's 4th row, Edward Pike and his wife Lucia, who had driven to the courthouse from the Millbrook neighborhood where they have operated their grocery store for 31 years. Edward was in the button-down shirt and light jacket of someone who had closed the store to be here. Lucia had a notepad on her knee. She had not opened it yet. 2 rows behind them in plain clothes sat Officer Dana Reyes. She was not testifying today. She was present in the specific way people are present when something they did correctly is about to be tested and they need to witness whether it holds. Before I could call the proceedings to order, Philip Crane rose to address the court. He described the matter as a misunderstanding, disputed the characterization of the door contact as resisting, and noted that Chief Wolf had submitted a character reference on his daughter's behalf and was available by phone should the court find it useful. He delivered that last sentence with the carefully calibrated casualness of someone deploying a name that has historically been sufficient. I did not respond to the framing. I asked Sandra Cho to present. Sandra Cho presented the parking lot security camera footage without preamble. She let it do what clear footage does when you simply allow it to run. The Mercedes entering the Millbrook Community Market parking lot. The speed documented at 41 mph in a lot posted at 15. The moment of impact. The rear corner of Edward Pike's delivery truck. The side mirror of the Mercedes shearing off. The visible jolt of the truck on its chassis. Then the 4 seconds at the exit. The store owner's face fully visible in frame. Edward Pike standing in the lot where he had just returned from a delivery run, looking directly at the vehicle that had just damaged his truck. The 4 seconds. The exit. I looked at Serena, I asked whether she disputed that her vehicle had struck the delivery truck. She said with the patient clarity of someone explaining something that should already be understood. There may have been contact. It wasn't significant. The truck was in her way, and she was late for something. Her insurance covers incidental parking lot contact. I said, Ms. Wolf, the footage shows you making eye contact with the vehicle owner at the exit. You saw him. You drove away. I want you to explain what you understood yourself to be doing at that moment. One shoulder lifted, a partial shrug, contained enough to be technically acceptable, dismissive enough to be understood by every person in the room. I was late. I assumed the insurance process would handle it. The insurance process requires you to remain at the scene and provide your information. I'm sure my father's office can facilitate the information. Exchange. The room went the specific still of a room that has just been told, plainly and without embarrassment, that a different set of procedures applies to the person speaking. I looked at her for a moment. Then I said, Ms. Wolf, your father's office is not a mechanism for facilitating civil traffic matters in my courtroom. What your father's office is the reason this court is now going to call him directly on the record. Philip Crane was on his feet before I had finished the sentence. The objection was immediate and professionally delivered. The chief's availability had been offered as a courtesy, not as an invitation to conduct an unscheduled examination on the record in an open proceeding. I asked my clerk for the phone number Philip Crane had himself provided in his own pretrial filing under the heading character reference available for court contact. She read it back to me. I thanked her. Serena's posture changed, not dramatically. She was too well practiced for drama, but visibly in the specific way of someone who expected a name to function as a ceiling and has just been informed that it is going to be examined instead. The call was placed on speaker in open court. Chief Raymond Wolf answered on the third ring. His voice was exactly what 16 years as the city's most senior law enforcement officer produces, measured, authoritative, the specific register of someone accustomed to being called and to the call meaning something. He greeted the court. He said he was glad to be of assistance. He said his daughter was a good person who had perhaps exercised poor judgment, and that he was confident the court would take her background and his family's commitment to this city into account. I said, Chief Wolf, I appreciate your taking the call. I want to ask you something directly. The officer who responded to the complaint against your daughter was Officer Dana Reyes, a patrol officer in your department. I want to ask whether you have had any communication with Officer Reyes, her supervisors, or anyone in the department's chain of command regarding this matter since the citation was issued. A pause. Chief Wolf said he may have indicated to her supervisor that he was aware of the situation and was monitoring it. I said, Chief Wolf, I want to make sure the record reflects what you just told this court. You contacted the supervisory chain of the officer who cited your daughter in a matter where your daughter is the defendant to indicate that you were aware of the situation and monitoring it. I want to ask you whether you understand what that communication functions as in the context of this proceeding. A longer pause. I understand how it might be characterized. I am not asking how it might be characterized, Chief Wolf. I am asking you to tell this court what you intended it to communicate. The silence that followed was the silence of a man who has been asked on a speakerphone in an open courtroom to describe something he understood clearly.
I've worn this robe for 34 years, long enough to know that justice isn't just about statutes, footage, or what's written on a docket. It's about choices. It's about what someone does in the few seconds when they believe no one is watching. One Tuesday morning in September, a case came before me that seemed routine: property damage, reckless driving, failure to stop, resisting an officer. Then I read the defendant's name and her father's. When she entered the courtroom, the atmosphere shifted. She arrived 17 minutes late, unhurried, composed, dressed with quiet authority. No apology, no urgency, just the confidence of someone accustomed to being accommodated. She carried her father's name the way some people carry credentials. Not displayed, but working for them nonetheless. When I asked why she was late, she calmly blamed parking. No apology. Her attorney quickly stepped in to offer one, but I addressed her directly. Court begins at 9 o'clock, and that's when you are expected to be here. She acknowledged it, but her tone suggested she didn't fully accept it. Her father had served 16 years as the city's police chief. His name carried weight, enough that systems often adjusted before anyone consciously chose to adjust. That morning, she arrived expecting it would. Her legal team tried to frame the case as a misunderstanding. They mentioned her father's willingness to speak on her behalf. I didn't respond to that. Instead, I asked for the evidence. The footage showed her car entering a parking lot at 41 miles per hour, well above the posted 15. It showed the impact of the delivery truck. And then it showed something more important. The 4 seconds at the exit. The truck's owner stood there, clearly visible. She looked directly at him. Then she drove away. When I asked her about it, she minimized the incident, said it wasn't significant, said insurance would handle it. When I pointed out that she made eye contact with the owner, she shrugged it off. She was late. Then she said something that shifted the room entirely. Her father's office could handle the information exchange. That was when I decided to call her father. On the record, he answered, spoke confidently, praised his daughter, expressed trust in the court. I asked him one question. Had he contacted anyone in the chain of command regarding the officer who cited his daughter? After a pause, he admitted he had. I clarified. He contacted supervisors in a case involving his own daughter to say he was aware and monitoring it. I asked him what he intended to communicate. Silence followed. Then he said he wanted to ensure the situation was handled appropriately. But it already was. What his contact communicated, intentionally or not, was pressure, and that became part of the record. Then additional evidence was presented. Audio from a building camera. Her voice was clear. Do you know who my father is? You won't have a job tomorrow. She said she didn't mean it literally. But the officer had documented everything anyway, fully, accurately, without hesitation. I made it clear that her conduct had been noted, and so had the officer's integrity. Then the victim spoke. He didn't perform a motion. He simply said he had run his business for 31 years and asked for nothing beyond what the law already provides. Then he looked at her and said, I just needed her to stay. That's all. 30 seconds. She saw me and she left anyway. That was the moment the case became clear. The ruling followed. Fines, restitution, probation, license suspension, and a mandatory course. But there was one more condition. 30 hours of community service at the very store she had driven away from. Not a donation. Not a check. Actual time. Presence. Work. She objected. Her attorney objected. I noted it and upheld every part of the ruling. In the weeks that followed, the system did what it should. A formal review was opened. Supervisors were counseled. Her father received a reprimand, the first of his career. The officer who filed a report was commended. The defendant completed every requirement. She paid restitution and included a handwritten note. I should have stopped. The store owner didn't frame the check. He framed the note. She completed her service hours, arriving on time, working quietly. Toward the end, she apologized in person, and this time it was heard. Months later, the department introduced a new policy requiring ethics reviews when officers' family members are involved in cases. That change came from what happened here. But the most important part of this case isn't the ruling or the policy. It's those 4 seconds. It's the moment when someone believes no one is grading them and makes a choice. Justice isn't about names, influence, or assumptions. It's about whether the system holds when it's tested. In this case, it did. And in the end, justice wasn't a punishment. It was a moment someone finally understood the weight of those 4 seconds and what it means to stay.